Welcome back to Ben's Bench, and as I said in the last video, this is a continuation on my Landlord Tenant series, and today we're talking about evictions. If a landlord wants to get rid of a tenant, either because they're exercising one of their rights due to a breach of the warranty of habitability, or they're breaching the lease in some other way, causing disturbances in the complex, what can the landlord do to get rid of the tenant? The first thing I'm going to say might come as a surprise on a channel about the law, but it's actually not really related to the courts at all. The first thing that the landlord can and probably should do is talk to the tenant. As I said in the last video, a residential lease is just a contract between the two parties, and if it's not working out, they can negotiate a way to end it early. So if the landlord wants to get rid of the tenant, he can attempt to negotiate an amicable split, allowing the tenant to walk away from the lease and the landlord to relet the premises. If it's doable, the negotiated termination, or whatever you want to call it, is actually the best way to get rid of a tenant because it's an agreement between the two. It doesn't involve going to court. That way neither party incurs legal fees, and the tenant doesn't have an eviction on their record. So if the tenant is amenable to such an agreement, then that's actually the first thing that should be attempted. Not everything needs to go through the courts. It is possible for the two parties to work out an arrangement on their own. Now, if that doesn't work, the tenant doesn't want to leave or is being very difficult, then the only other option is for the landlord to go to landlord tenant court and file for an eviction. It is important to keep in mind that the procedures and prerequisites for filing an eviction are going to vary from place to place. But once it's filed, in most situations, a case can go through landlord tenant court fairly quickly. The legal issues are not really that complex most of the time. The factual findings are fairly easy to do, so it's not like complex litigation that can sometimes take years to resolve. It really is a fairly quick proceeding. It's also pretty easy to file an eviction. A quick internet search will indicate exactly what court handles landlord-tenant matters and how to file a complaint with that court. Some courts also offer mediators who sit down with the landlord and the tenant and try to help them come up with an agreement that works for both of them, which, of course, if that happens, then their case is dropped and they proceed according to the terms of the agreement that they've worked out with the mediator. Now, an eviction does require some work and some fees. What if the landlord doesn't want to go through all that bureaucracy and just wants to get rid of the tenant? What can they do? The answer, quite plainly, in all states, is nothing. If negotiations have not produced a favorable result, that is, the tenant is not inclined to enter into an agreement to leave, and the process of eviction is not all that appealing, the landlord cannot summarily lock out the tenant. That is called a self-help eviction. Self-help evictions are illegal in every single state. No state allows a landlord to lock out a tenant or do anything else that would force the tenant out, such as using violence or threats of violence, removing the tenant's property, shutting off utilities in an attempt to get them to leave. Those are all considered types of self-help evictions, and it gives the tenant the right to sue in court, in some places for double or triple damages, and in some places, including the state of New Jersey, it's a crime. In places where self-help eviction is a crime, such as New Jersey, the police can get involved, they can arrest the landlord, and a judge can assess fines or even order jail time if a landlord has engaged in a self-help eviction against a tenant. Now, why is this? Well, in the landlord-tenant relationship, the landlord has a lot of power. They're often the one who has written the lease. There's not a lot of negotiation involved. It's here's the contract. You either sign it or you will not. And the tenant doesn't really have a lot of room to negotiate anything. So the law gives the tenant a little bit more power behind them to try to strike more of a balance between the landlord and the tenant. Now, as I said in the last video, it is important to remember that this is just general information, relatively baseline stuff. If you are facing an actual landlord-tenant issue, whether you are the landlord or the tenant, you absolutely should seek the help of a local licensed attorney who knows the laws, the regulations, and the court precedents in your state, your county, or your city to know exactly how to proceed with an eviction if you're the landlord, or how to defend against an eviction if you're the tenant. So to recap, negotiation should be attempted before any kind of court proceedings are initiated. It's easier on everybody, and if it's possible, it eliminates a lot of the work and the costs involved in going to court. If such negotiation fails to produce a result, then filing an eviction in landlord-tenant court is the only other way to get rid of a tenant. A landlord cannot lock a tenant out. A landlord cannot throw out a tenant's belongings. A landlord cannot shut off utilities. Those are all considered a form of self-help eviction, and it opens the landlord up to liability in civil court, often for enhanced damages, and sometimes even criminal liability. And finally, if you are facing a legal issue, find yourself a local licensed attorney who knows the law and the procedural rules. It's not a requirement to get a lawyer. That is, it's not a legal requirement, but it is highly recommendable. Going pro se is a big risk. But we can talk about the pitfalls of pro se litigation another time. For now, we're adjourned.